Trade show season is here, and if you're an innovator who is excited to reveal a new product you've been working on, I've got a recent case to tell you about that provides a stark lesson of what can happen if you delay filing a patent application until after you show your new product at a trade show. The case is Nobel Biocare Services versus Instradent USA. Nobel owns a U.S. patent filed on May 23, 2004, directed to a particular type of dental implant. The patent was originally filed by a company named Alpha Biotech, which I'll abbreviate ABT, which Nobel later acquired in 2008. The dispute was hotly contested by the parties and twice went up to the Federal Circuit on appeal, which handed down its final dispositive decision on September 13, 2018. The case started when Nobel filed a complaint against Instradent before the International Trade Commission in an effort to block Instradent from importing a competing dental implant product into the United States. Nobel argued that Instradent's product clearly infringes their patent, and the ITC and Federal Circuit agreed. So it's important to recognize that this case did not involve the question of infringement. Infringement was established by Nobel. The only question in this case was whether Nobel's patent was valid or not. Instradent pointed to an ABT product catalog with the date March 2003 on the cover and argued that the same dental implant claimed in ABT's later filed May 23, 2004 patent application was also disclosed in that catalog. Instradent therefore argued that ABT's own prior disclosure invalidated its later filed patent application. The court focused on the issue whether the ABT product catalog was publicly accessible. The court found it was, based on the evidence in the record, which centered on the testimony of a single third-party witness who testified at trial that he attended a trade show in March 2003 and brought home the ABT product catalog. This was enough to convince the court that the ABT product catalog was publicly accessible. Ultimately, the court ruled the ABT product catalog anticipated and therefore rendered invalid ABT's, later Nobel's, patent. U.S. law requires inventors to file a patent application no more than a year after he or she publicly uses, discloses, or sells an invention. The U.S. is generous compared to the rest of the world, which does not provide a one-year grace period that the U.S. provides. Outside the U.S., if an inventor waits to file a patent application until after he or she publicly discloses, uses, or sells an invention, the patent can be held invalid. At least the U.S. gives you a year. This case offers a lesson to innovators that it doesn't take much to blow your patent rights. Launching products at trade shows is a very common occurrence, one that I've seen my clients engage in many times over the course of my career. However, if you're not aware of the rules regarding the timing of the filing of patent applications relative to commercial activity, you can end up forfeiting your patent rights. I'm sure the market for the dental implant product in question in this case was quite valuable, or else the parties wouldn't have spent so much time, money, and resources litigating the issue for several years. So putting this all together, before you launch a product at a trade show or anywhere for that matter, I recommend you do the following. Talk to your patent counsel and get an opinion of patentability. If the product is patentable, file a patent application before publicly launching or disclosing the product. Before publicly launching or disclosing the product, get a non-disclosure agreement in place with any third parties you disclose details about the product to. This will render the disclosure effectively non-public. If you already disclosed the product, it may not be too late to file in the U.S., however, it may be too late to file outside the U.S. Talk to your patent counsel right away. Thanks for listening and have a great day.